There are some fairly alarming legal developments going on in the world just recently with respect to transgender medical intervention treatment that I'd like to address briefly in this video. But also in this video, whether or not AnheuserBusch, parent company to Bud Light, after recently losing $6 billion off their market cap, really have apologised for using Dylan Mulvaney in their advertising and where that stems from. And also in this video, a brief look at the law of England and Wales, recent case decisions and on how that relates to the legal developments in the United States. And finally, I'll leave you with a very good reason why this is a hotly debated topic that everybody really should pay attention to. So stay tuned. Welcome back to the channel. I enjoy addressing you on various points of legal development, and I'd really appreciate if you subscribe if you find this video useful at any point. So without further ado, let's move first of all why people believe that there's been apologies from AnheuserBusch and whether there's any truth to that. Now, many of you may know I'm a contributing author for Thomson Reuters on their legal blogs, but I use Thomson Reuters for fact checks as many other people do. This was written shortly before the statement from the CEO, which I'll come to in a moment. And Thomson Reuters have gone through and essentially debunked this idea that there's been a formal apology and various examples of emails that have floated around that there's been an official apology for this so-called Bud Light fiasco. Now, the spokesperson for AnheuserBusch said that there is no truth to these statements, and also Thomson Reuters said that they could not find any credible news or outlet or other reporting that the CEO made such an apology for this partnership with Dylan Mulvaney. So any such apology in that regard has been debunked. However, there has been a recent statement from the CEO, which has been met with equal criticism, really, in the sense that it didn't really seem to say a lot at all, other than this is the history of the company, this is what we do. And the pertinent point in the middle here was really that we never intended to be part of a discussion that divides people. We are in the business of bringing people together over a beer. Now, I made a comment on one of these such threads yesterday, to the extent that this was what was going to happen when a company uses in their marketing something, a subject matter, which is a hotly debated topic. Somebody replied to me to say, this is not up for debate, or this is not in debate, or words to that effect. And I said, well, of course it's in debate. Lots of people are debating it. And that's what brings me to the point of this video. Because in essence of debate, all law is debated before it is made law. Any bill that comes before any legislative body is, of course, debated back and forth by both sides of the House or whichever jurisdiction you're in before it becomes law. And what I'm talking about, of course, is Washington State's Bill 5599, which is called Supporting Youth and Young Adults Seeking Protected Healthcare Services. But what it really means is that the House has approved a bill which authorizes the hiding of children who are seeking transgender medical intervention from their parents. Now, most parents would, I certainly hope, agree that it's a parent's job to make decisions for that child that is in the best interests of that child. Now, many of those issues may be of hot debate between other parents or between other people, which, quite frankly, they might not agree on. However, it should be the parents, in my view, as a professional and as a parent myself, it should be the remit of those parents to make decisions for the children that are in their best interests, decisions which they may not be able to make themselves and they may not have the capacity to consent to themselves. In the medical sense, we call this being Gillick competent. If a child is not Gillick competent, then they cannot consent to the medical treatment themselves, and therefore someone else must do that for them. But this bill is taking this one step very much further than that. This is saying that if children are seeking medical intervention for a transition from male to female or female to male, that the very fact that these children are seeking such medical intervention can be hidden from their parents. As described here, essentially what the bill would do would be if a child left a parent's home for certain medical care and went to a shelter or host family, that shelter or host family would not be required to notify parents of their child's whereabouts, which, as reported here, which for what it's worth I agree with, is an obvious fundamental violation of parental rights and something that should be deeply concerning for parents across the Washington state. Moving briefly to the law of England and Wales, there was a case that involved prescribing puberty suppressing drugs to persons under the age of 18, which of course are children or young persons. This claim in particular was for judicial review of the practice of the defendant in this case for prescribing such medicine to persons under the age of 18 who experienced gender dysphoria. And so this may also help people to understand a little bit further what this is all about. Gender dysphoria is a condition where persons experience distress because there is a mismatch between their perceived identity and their natal sex, i.e. what they were at birth. Such persons having a strong desire to live according to their perceived identity rather than their natal sex. This case discussed the fact that puberty blocking drugs can, in theory and in practice, have been prescribed for gender dysphoria through the services by the company in the case, provided to children as young as 10. It's the practice of the defendant through the service to require informed consent of those children and young persons to whom such drugs are being prescribed. The issue at the heart of this claim was whether informed consent in the legal sense can be given by such children and young persons. If I skip down to the overall conclusions in this case, the court said a child under 16 may only consent to the use of medication intended to suppress puberty where he or she is competent to understand the nature of the treatment. That includes an understanding of the immediate and long-term consequences of treatment, the limited evidence available as to the efficacy or purpose, the fact that the vast majority of patients proceed to use the cross-sex hormones and its potential life-changing consequences for a child. There will be enormous difficulties in a child under 16 understanding and weighing up this information and deciding whether to consent to the use of puberty-blocking medication. The court's view was that it is highly unlikely that a child aged 13 or under would be competent to give consent to the administration of puberty blockers. It is doubtful, the court continues, that a child aged 14 or 15 could understand and weigh the long-term risks and consequences of the administration of puberty blockers. In respect of persons aged 16 or over, the legal position is that there is a presumption that they have the ability to consent to medical treatment. Given the long-term consequences of the clinical interventions at issue in this case, and given that the treatment is as yet innovative and experimental, we recognise that clinicians may well regard these as cases where the authorisation of the court should be sought prior to commencing the clinical treatment. We have granted the declaration to reflect the terms of this judgment. So in short, the court's view is that it's highly unlikely that a child of 13 or under would be competent, and that a child of 14 or 15 would be highly doubtful as to whether they can understand the long-term effects. And even for young persons, 16 or 17, that means, albeit where the legal position is that they have a presumption that they have the ability to consent to medical treatment, given the long-term consequences, the court's permission should be sought before commencing such treatment. Now, there was a second case that came to court on these very facts, that being specifically whether or not parents could provide consent on behalf of the child if the child, him or herself, was not deemed competent, at least in the court's eyes. The court's conclusion in this case is that the parent's right to consent to treatment on behalf of the child continues even when the child is Gillick competent to make the decision, but doesn't do so. Although, of course, the parent's decision cannot override the decision of the child where that child is Gillick competent. So in other words, if the child is able to make the decision themselves but doesn't, the parent can make that decision for them. But of course, if the child makes a decision, the parent cannot override that decision. There are lots of issues within this case, and I will try to remember to link to these judgments so that you can read them in the description below. But as I said, I feel that the legal developments are fairly shocking in Washington state, where it may well be that all of this information is hidden and concealed from parents, where children are seeking out medical intervention. Remember, there are immediate and severe effects and indeed long-term effects of such treatment. And so with that in mind, I will leave you with one short video, which is a young girl who transitioned to be male, having been born female, and within 1 year, having transitioned surgically at age 15, detransitioned just 1 year later. Whereas, of course, there were already serious and permanent medical repercussions. Take a look at this.
I have 2 giant scars across my chest that remind me every day that I was butchered by the institutions that we all thought we could trust. I went to my surgeon because I was desperate for answers, and he just told me, "It's fine. That's completely normal. Just put Vaseline over it," which didn't make sense to me, but I thought that because nothing else was working, I might as well try it. That gave me a skin infection. It hasn't healed at all, and the wound, whatever it is actually spreading across my chest. I have no clue what's going on. I have nowhere to turn because I no longer have any trust in Kaiser Permanente, and I can't afford treatment out of pocket. I wish I could have my breast back, but a reconstruction may be riddled with even more complications, and no matter what, I will never be able to breastfeed my future children.
So there's some fairly serious words on just how devastating medical intervention can be at such a young age, when somebody changes their mind because they were not entirely understanding of what the short and long-term consequences of that treatment are. And so, as I said, some fairly shocking legal developments across the world, particularly if it's going to hide all of this from parents. And the first parents might hear of it is when it's far too late because the treatment has already been done. Let me know what you think in the comments, whether you think this is a good thing, a bad thing, and whether you support this new legislation in Washington state. And just let me know what your views are. This is a debate. It's a debate that everybody should have. It's something that everybody should be aware of, and you really should be talking to your children about it. So with that in mind, please do remember to like this video and subscribe, support my channel, helping you understand law. And as always, I thank you for watching.